Good morning, everyone. I'm going to wait a few extra seconds this morning because I don't know about you, but our office had some trouble with Zoom and a Zoom update, and it took a little longer for us all to log in. So I'm just going to wait a little bit longer because I think some of you may have had a similar experience. All right, good morning. I'll go ahead and get started. If we have a few people who join us while I'm making our normal introductions, that's of course fine. We have a few things to get through before we get to anything substantive, I think. Good morning. My name is Nicole Kinsey. I'm a hearing officer with the Administrative Hearings Office of the State Water Resources Control Board. It is May 2nd, 2022. Unlike last time when we convened, it is not raining, at least not where I am, unfortunately. But here we are. This is a hearing for Phase 1B on the applications of North Kern Water Storage District and City of Shafter, application 31673, City of Bakersfield, application 31674, Buena Vista Water Storage District, application 31675, Kern Water Bank Authority, application 31676, Kern County Water Agency, application 31677, and Rosedale Rio Bravo Water Storage District, application 31819. And these are all for permits to appropriate water from the Kern River system. This hearing is being held in accordance with the notice of public hearing dated January 12th, 2022, and the amended notice of public hearing dated February 9th, 2022, as well as the pre-hearing conference ruling dated March 18th, 2022. This hearing is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording and the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If you are experiencing technical difficulties trying to communicate with us today, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov. AHO staff will be monitoring the email inbox and will let me know that you're having trouble communicating through the Zoom platform. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Amy Blanc, Skylar Anderson, and Kyle Wooldridge. Ms. Mullen, as usual, will be handling the screen sharing of exhibits and moving along the slides for us. So if you are a witness today and you would like to advance your slides, please simply ask Ms. Mullen to advance to the next slide when you're ready during your testimony. And of course, attorneys, you may ask Ms. Mullen directly to bring up a particular exhibit as you see fit through in cross-examination, et cetera. If at any time I am experiencing technical difficulties during this hearing today, hopefully not, but it sometimes happens, and I'm not able to rejoin the Zoom conference within a few minutes, one of my staff will call a recess until I am able to rejoin the Zoom platform. We will take breaks today. We'll have a mid-morning break and then lunch and so forth. If any of you need a break, please just let me know at an appropriate time. And also, please don't hesitate to remind me to take a break. Sometimes I get excited and I realize we've been going for 2 hours and not taking a break. At this point, let's move to roll call. Move to appearances. To do that, I will identify each of the entities that filed NOIs for phase 1B of this hearing. And as I do, if you're representing that entity today, please unmute your microphone and state your name. I will go in our usual order just to keep things simple. So I will start with the City of Bakersfield.
Yes, good morning, Ms. Kunze and State Board staff. This is Colin Pierce appearing for applicant City of Bakersfield.
Good morning, Mr. Pierce. City of Shafter.
Good morning, Sarah Foley of Best Best and Krieger for City of Shafter.
Good morning, Ms. Foley.
Morning.
North Kern Water Storage District.
Good morning, Hearing Officer Kunze. This is Scott Cuney appearing on behalf of North Kern Water Storage District.
Thank you, and good morning, Mr. Cuney. Buena Vista Water Storage District.
Good morning, Ms. Kinsey, Ryan Becerra, Barkowitz, Chronic, and Shanahan for Buena Vista Water Storage District. With me today is Isaac St. Lawrence, the district's general counsel.
Good morning, Mr. Becerra and Mr. St. Lawrence. I see that you're named, and I don't know if that's us or you, Buena Vista 2. Are you going to be using this camera for witnesses, or is there any reason we shouldn't rename it with your name?
You can rename this one with my name, yes.
Okay. Sometimes because when the witnesses change and then our Zoom transcript gets all, gets confused. But if it's just you. Okay. Thank you.
Mr. St. Lawrence's camera is the one we'll be using for witnesses.
Thank you. That's helpful. Rosedale Rio Bravo Water Storage District.
Good morning, Jennifer Spoletta for Rosedale Rio Bravo Water Storage District.
Good morning, Ms. Spoletta. Kern Delta Water District.
Good morning, Ms. Kenzie. Craig Carnes with Ellison Schneider, Harrison Donlin for Kern Delta Water District, and Richard Iger, General Counsel, is also on.
Thank you. Good morning, Mr. Carnes and Mr. Iger. Kern County Water Agency.
Good morning, Ms. Kinsey. Nick Jacobs with Somac, Simmons and Dunn for Kern County Water Agency.
Good morning, Mr. Jacobs. Tulare Lake Basin Water Storage District.
Good morning, Ms. Kenzie. This is Peter Keel for Tulare Lake Basin Water Storage District.
Thank you. Good morning, Mr. Keel. Kern Water Bank Authority.
Good morning, Ms. Kenzie. Kevin O'Brien of Downey Brand for Kern Water Bank Authority. Also appearing with me today is my colleague Sam Bivens, and I'll ask Mr. Bivens to introduce himself.
Good morning, Ms. Kenzie. Sam Bivens, Downey Brand for the Kern Water Bank Authority.
Thank you. Good morning, Mr. O'Brien and Mr. Bivens. The public interest groups, that is Bring Back the Kern, Kern River Parkway Foundation, Kern Audubon Society, Kern Cahuilla Sierra Club, Panorama Vista Preserve, and Center for Biological Diversity.
Ms. Kunze, I heard from Adam Keats last week that he was not going to participate in this phase of the hearing, at least as far as I know.
Thank you, Mr. Pierce. And it does seem that Mr. Keats isn't here, so thank you. And then do I have anyone from the California Department of Fish and Wildlife? And then I see on the line we have Mr. Rose from the State Water Resources Control Board. Mr. Rose, would you like to introduce yourself?
Good morning, David Rose from the State Water Resources Control Board, here just to, I guess, audit the proceedings on behalf of the potential witnesses from the Division of Water Rights, but not participating otherwise. Thank you and good morning.
Thank you. Good morning, Mr. Rose. Is there anyone else who intends to participate during this hearing who has not already identified themselves other than our witnesses and who would like to identify themselves at this time? Moving on, I thought next what I would like to do is check in. I don't think we talked about this at the pre-hearing conferences, but whether there are any parties who are planning or anyone else is planning to give a policy statement or an opening statement that's not associated with case in chief evidence. I just thought I'd get a little roll call on that so I know what we are marching through today. I did want to raise specifically, I have in my notes, I realized, Mr. Pierce, that the City of Bakersfield filed an opening brief. So I specifically wanted to ask you whether you're planning to make an opening argument or something similar.
No, we're not, Ms. Kunze. We're going to stick with our opening brief.
Okay, thank you, Mr. Pierce. Is there anyone else who's planning to make an opening statement not associated with case in chief evidence or a policy statement? Good, thank you. Moving on to evidentiary objections, you may have received within the last probably 20 minutes or so this morning, a written evidentiary ruling that addresses the motions that I received on April 18th. With the exception of KWBA's motions, I'm going to address that in a subsequent written ruling before we hear from Buena Vista's witnesses, because that would go to those issues. But there are also, you'll see in that ruling, I'm sure you, or I imagine you haven't had a chance to read it yet, but there are some elements of the evidentiary motions that I deferred until we'd reached the testimony of a particular witness. So I will ask that we all make our best efforts to keep track of those. Please don't hesitate to remind me if there are portions of an evidentiary motion that are still outstanding when we get to the admission of party exhibits at the end of their cases in chief. I also am considering whether it may make sense in some instances to address those portions of the evidentiary motions immediately after the particular witness testifies and has been cross-examined, because sometimes this is complicated and it may help me to address those evidentiary motions once we've immediately heard from the witness and you've had a chance to cross-examine the witness about some of the foundational issues about sources and the basis for their opinions and things like that. So I wanted to put that out there. We can go back, revisit that issue. Before we get to any admission of evidence, anything like that, I will of course give you the chance to read the evidentiary ruling. So we'll be sure to take a break at some point that's appropriate before we move along. But feel free to ask if you would like the break to read the ruling. Other than the evidentiary objections that we received on April 18th, are there any other evidentiary matters that we should raise? I'm going to say I'm going to get to the joint stipulation about the deposition testimony, and then I'm also going to get to KWBA's request for official notice. So those two things I realize are outstanding. But other than that, are there other evidentiary issues that we should address as housekeeping at this time? I see Mr. Becerra and Mr. Cooney, you're both unmuted. So I saw Mr. Becerra first, I'll go there first.
Thank you, Ms. Kinsey. Yes, yesterday, Buena Vista submitted a supplemental objection to the testimony and exhibits of Dr. Jeffrey David on the grounds of late, inadequate, and improper disclosure of the underlying technical data on which he relies. We did not receive adequate disclosure of even the subject of, the materials on which he relied until Mr. Parker submitted a declaration on April 25th, 3 weeks after the case in chief evidence deadline. I just want to note our objection for the record. I assume that you will consider it along with the remainder of our objections. I did skim your ruling. I understand your perspective on the timing of how to handle Dr. David's testimony.
Thank you, Mr. Becerra, and thank you for the reminder. I did see that supplemental objection come in. I did not. I have not reviewed it, so I will review it. And as you mentioned, I had reserved the ruling on some of Buena Vista's objections to Dr. David's testimony and the underlying sources. So I think it would be appropriate to consider those supplemental objections at the time we address those remaining objections from your initial motion. And we'll get to that. What I've just considered to be an appropriate time is after Dr. David has testified and the parties have had a chance to cross-examine him about his sources. And we'll have a little more information, at least for me, about the basis for some of those objections. Anything else, Mr. Becerra, before I move on?
No, thank you very much.
Thank you. Mr. Cooney, I'll turn to you next.
Yes, thank you very much. We have reviewed quickly your letter ruling on the evidentiary objections, and at the right time, and I defer to the hearing officer as to when that is, we would like to propose a standing objection as it relates to parties advocating that there has been a revocation or a reopening or a reconsideration of state board orders. Again, I'm proposing it as a standing objection at the front end before any testimony is taken so that we can avoid disrupting the processing of examination by question. So whenever it's appropriate.
Ms. Kinsey, Ryan Becerra for Buena Vista, we would agree with Mr. Cooney on that sort of standing objection.
Thank you, Mr. Becerra. What I'm wondering if we should
We'll
do
join
it
it.
now. Mr. Jacobs, thank you. Maybe we should do this now because here we are. So, Mr. Cooney, would you like to articulate in any more detail the standing objection that you would like to lodge?
And I would like to articulate the objection, and so please bear with me. I appreciate the opportunity. We wish to make an objection in advance of the presentation of any of the evidence that is going to be heard in phase 1B, so that the record is clear on these primary foundational issues that relate to the testimony or exhibits for those that are advocating that the state board's prior orders have been reopened or reconsidered. And specifically, this objection is made with regard to state board's decision 1196, water right order 8925, water right order 9107, water right order 94-1, water right order 9808, water right order 2010-0010, and finally water right order 2010-016, excuse me. And our objections are based on the following legal principles. Quote, there is a general doctrine that unless permitted by statute, an administrative agency may not reopen or reconsider an adjudicative decision, quote. And this is the case in re Tokhamanian, Tokhmanian. It's a 2008 decision, 168 Calap 4th, 1270, page 1273, footnote 2. A second authority that we cite to the hearing officer is Water Code section 1205C, that the state board or its agents cannot revoke or revise a declaration that a stream system is fully appropriated unless they comply with that statute. Likewise, California Code of Regulations 871B provides that a revision of such a decision is limited to change in circumstances from those considered in the previous water right decision. And there is no authority for the state board to reinterpret prior orders. Limited by these legal constraints, the board, its prior decisions resulted in Water Right Order 2010-0010 was limited to addressing only two potential changes in circumstances. One was the North Kern forfeiture decision, which has now been fully addressed in phase 1A. And the second was the discharges of floodwaters into the California aqueduct, which is now proposed to be addressed in this phase 1B. It was only those two changed circumstances that were identified by the state board's water rights division chief that allowed for the processing of the petitions that ultimately were heard in the 2009 hearing. And importantly, that decision that resulted following the hearing, again, Water Right Order 2010-00110 states, quote, the purposes of this proceeding, that being the 2009 proceeding, is to determine if there has been a change in circumstances since the Kern River was included in the declaration. And the parties were requested to limit evidence and testimony to showing that periods of flows exceeding recognized rights have become available since the board listed the Kern River as fully appropriated. And that's on pages 2 and 3 of that decision. Ultimately, the state board determined that water diverted into the intertie is in excess of traditionally held and exercised rights and claims of right to the Kern River. And that's a quote from that decision, page 5. As a result, in Water Right Order 2010-010 provides that, quote, based upon those foregoing findings, one, the declaration as adopted by the state board in orders Water Right 8925, Water Right 9107, and Water Right 9808 is amended to allow for processing applications to appropriate waters of the Kern River, quote. That's how we came to this proceeding. And it's also important as another authority is the Court of Appeal in a unpublished decision, but which can be cited to you because as it relates to the scope of that decision in terms of its the issues determined. And this is a Westlaw citation, it's 2013 1682466, said that it reviewed the petition challenging Water Right Order 2010-010 and expressly confirmed the limited scope and effect of Water Right Order 2010-010, quoting the state board's order that said, quote, focus of the board's inquiry was the relatively narrow task of determining if the evidentiary record supports revising the fully appropriated status of the Kern River. Also importantly, the Court of Appeal ruled that the state board has, quote, neither asserted nor exercised the power to reduce the appropriative rights pursuant to which appellants, North Kern, Buena Vista, and the Kern County Water Agency now receive water, quote. And that's at page 10 of the Court of Appeals decision. It's our contention that any proffer of evidence in phase 1B seeking to reopen or reconsider the state board's prior decisions and orders regarding the Kern River is contrary to law and beyond the lawful jurisdiction of the state board. And I cite to the hearing officer, Eaton versus the State Water Rights Board. And I know that you've cited it in your ruling. I did notice that today. So you know that citation well. And secondly, any evidence seeking to reopen or reconsider prior decisions are irrelevant to determining the identified phase 1B issues, we believe, under the government code. And lastly, we believe it would be a violation of due process to accept evidence seeking to reopen and reconsider the state board's prior Kern River orders in phase 1B hearing for the reasons stated above. So really our conclusion is that the state board's order, Water Right Order 2010, is really very clear that the state board's prior orders were amended only to allow for processing of applications to appropriate waters of the Kern River. And the lawful scope of these proceedings is limited to the two changed circumstances identified and adjudged in that hearing, and that one being whether or not the forfeiture decision results in unappropriated water, or whether or not the discharges of floodwaters into the intertie results in unappropriated water. And that those that are advocating that in some manner those prior orders and decisions of the state board have been revoked, overturned, or superseded, or should be, is not within the scope of this hearing. And as I introduce this, to avoid going through this each and every time somebody is asked a question that I think gets out of bounds, I would request that this be a standing objection that is at the front end of this evidentiary record, and that those questions then that we find objectionable will be subject to these legal objections and be resolved as appropriately by the hearing officer and those that review this decision.
Thank you, Mr. Cuny. I will make some comments and then we'll see, decide if it's appropriate for others to participate. I'll certainly make sure that everyone has an opportunity to join the objection or oppose the objection on the record. I do want this in writing, Mr. Cuny. And so the question is going to be, when is the best time to do that? And how should we do that in a way that's gives an appropriate opportunity for response from the other parties? This, of course, is so far, we haven't even gotten into the evidence. It's one of the most challenging aspects of this proceeding, and it's been raised. And I thank you for this consistently since the beginning of this proceeding. So we're certainly all aware of it. I think for those who've had a chance to look at the evidentiary ruling, I was very clear that, or tried to be very clear that, although I was ruling on the motions for purposes of admitting evidence so that we can move forward with this proceeding, that I was making those rulings without prejudice to any party raising these issues substantively about the appropriate scope of this hearing and the appropriate matters to be addressed in any proposed order that would then go to the board out of this proceeding. So Mr. Cooney, your objections are well taken. I think it's well timed, and it's probably a good idea for us to talk about the best timing to address these in writing. I had thought, I mean, initially I was thinking, well, we'll just wrap this into closing briefs. We can do that. It just, but I realize it may make some sense to distinguish between closing briefs that address the evidence in substance and then this somewhat independent legal question. So I'd like to hear from you, but I will be willing to set a separate briefing deadline, whether we do it after the close of all of the evidence, after rebuttal in June, we can do it then, or we can schedule it at an earlier time if you can convince me if it's appropriate between case in chief and rebuttal. So I'm thinking about all of these things, but that's where I'm at. I will, what's the best way to organize this? Maybe I know, Mr. O'Brien, you're going to have one chance to respond, obviously, and I will give that to you. I will turn to the other parties who may be joining this objection, and then I will turn to you, Mr. O'Brien. So Mr. Becerra, you unmuted first, so I can turn back to you.
Thank you, Ms. Kinsey. Yes, we agree with Mr. Cooney's perspective. We'd also like to add a couple of matters. First, in adopting the fully appropriated stream declarations in 1992, the State Board expressly addressed this issue and expressly removed reinterpretation of prior decisions as grounds for reopening fully appropriated stream declarations. It did so based on the comments of many Kern River agencies, including the express comments of Buena Vista Water Storage District, which stated in an August 26, 1992 letter, the exact concerns that are occurring in this hearing, that we would rehash arguments over and over again. So what we are litigating existing rights in this proceeding is beyond the scope of fully appropriated stream proceedings as defined by the State Board in the regulations in 1992. Second, proceeding with re-adjudication of existing rights, particularly Buena Vista's existing right, which is the primary one being attacked in this proceeding, is a violation of fair hearing and due process procedures. We did not receive any notice of the actual grounds of the attack until last Monday in Kern Water Bank Authority's opening brief, when for the first time, among other things, they asserted that the deed from 1927, under which Buena Vista Water Storage District obtained its rights, doesn't actually convey those rights to Buena Vista. Kern Water Bank Authority filed its complaint against Buena Vista in, I believe, August of 2019. Division of Water Rights dismissed it in December of 2020, and yet we have continued. As I said, we did not receive adequate disclosure of the grounds of that attack until last Monday. It is a violation of fair hearing and due process to litigate Buena Vista's rights in this way. And I would contrast that with the grounds for the State Board itself to bring a cease and desist order, under which the board must state the facts on which it is seeking that order at the beginning of the process. That has not happened here. And what is occurring now is a violation of Buena Vista's fair hearing rights if we proceed in this manner. So our authorities on those matters were asserted in our briefs. The Rosenblit case in particular is on point. And so we would join Mr. Cooney's arguments and standing objection on those grounds. Thank you.
Thank you, Mr. Becerra. And I did read your motions, and I did actually read the attached evidence and the regulatory, what I'll call regulatory history behind the regulations adopted in 1992. I won't repeat what the statements I've already made in the written ruling that you received this morning, but I just will note, just for the record, that this is not a proceeding considering a cease and desist order or any order by the board that would direct Buena Vista to alter its diversions and use of water in any way. So I just want to make that clear, that the scope of this proceeding is to consider the amount of unappropriated water that's available for these pending applications. On that, so I understand, Mr. Becerra, that this, I mean, what I'm taking, the way I'm understanding the standing objection, it's an evidentiary, to some extent, it's an evidentiary standing objection, but I think we're also talking about here about substantive objections to the scope of this proceeding before the board. Do you have any comments or thoughts about how you would like to submit additional arguments, if you have them, or written arguments on the substantive issue and when in the course of this proceeding you think it'd be appropriate to do that?
At this point, Ms. Kinsey, I'd say we should probably just put it in our final briefs. We are on something of a accelerated schedule, let's say here.
Sure.
And we have briefed the matter. We've stated our perspective. We will do so again in our final brief following hearing the evidence.
Thank you, Mr. Becerra. And I think that, and I will turn to that. I mean, I think that it may implicate page limits for the final brief, but we can accommodate for that.
Thank you.
And I think Mr. O'Brien, did you, let me still hold on that for now, Mr. O'Brien. Mr. Cooney, did you have anything else to add? I see you're still off mute, so I wanted to make sure I turn back to you.
I have nothing further to add, but I mean, if you want what we have stated here this morning in writing, I can do that, or I think it may be most efficient to integrate it into briefs, to be honest with you, but I want to be facilitating to you. I know that was a lot to take in at a front end of a hearing. I had no other means in which to do it, and I apologize for the amount, but nonetheless, we wanted to make certain that these foundational issues were at the front end so that we had not inadvertently made a waiver on such an important matter. But I think for efficiency's sake, it's probably best, let's include this in briefs, and undoubtedly you will be addressing these very important matters appropriately at the conclusion.
Thank you, Mr. Cooney. Mr. Jacobs, I will turn to you. I know you, I heard you join the objection, and I wanted to hear from you explicitly.
Just wanted to confirm the Kern County Water Agency joins Mr. Cooney's objection. And we've briefed the collateral estoppel issue in our opening brief with citations, including the cases regarding administrative findings in prior proceedings.
Thank you, Mr. Jacobs. At this time, I will turn to you, Mr. O'Brien, and then if there's anyone else who wants to comment, or Mr. Bivens, we'll go from there.
Thank you, Ms. Cooney. Ms. Kinsey, sorry. You know, I don't want to get into a long substantive argument this morning. We're ready to start this evidentiary hearing. Many of these issues have already been briefed. And I looked quickly at your ruling this morning, and I understand, I think, where you're going on most of the issues. I think the idea of giving us a full and fair opportunity to respond to these arguments in a brief is the best approach here. I'm a little concerned if we have simultaneous post-hearing briefs, it may not be set up in a way where I can respond directly to the arguments that have been made. So we probably need to think about that a bit. But I don't really think we've heard anything new this morning, and we've already briefed the evidentiary motions. We've set forth our arguments, and I don't really have anything to add at this point.
Thank you, Mr. O'Brien. And just to note, I think we should return to this later on in the proceeding, but I'm not initially opposed to the idea of having post-hearing briefs, and then particularly where there's substantive legal issues, having responses to those briefs, so that there'll be opportunity for both sides to respond to the other arguments. Do any of the other parties wish to chime in, either to join in the standing objection or make any of their comments about this issue?
Yes, I would. Just City of Shafter would like to join in the request for standing objection as articulated by Mr. Cooney.
Thank you, Ms. Foley. Noted. Anyone else? I think on that, are there any other evidentiary objections that we need to address before we move forward? Mr. Jacobs.
I just want to make clear, I have not read your order. So if we're just going to roll into testimony,
we know we need to
make my objections as they come up, or?
Yeah, well, we have a few more housekeeping items to get to, so let's work through those, and then we'll likely what I'll do is I'll take a break.
Ms. Kinsey? Oh,
yes, Mr. Becerra.
Ryan Becerra for Buena Vista. Can we assume that the standing objection is in place at this point?
Yes, the standing objection is in place. Is that one? I was going to say, I'm not sure what one does truly with the standing objection, but it is noted. It is there. It is in place. To the extent I'm not going to exclude evidence on the basis of the objection. We're going to move forward. But I understand for the record that it's in place, and to to the extent substantive issues are raised, I will address them in any final proposed order that's submitted to the board.
Thank you.
Is that fair? Okay. So I'd like to turn next to the joint stipulation. I think KWBA submitted it, but it was signed by, I believe, most and possibly all of the parties on this Zoom conference today. That was submitted on April 25th, and it's a joint stipulation to enter the transcripts of the depositions of Mitchell Moody and Matthew McCarthy into the evidentiary record, along with associated exhibits that were cited in their, or referred to in their testimony. Based on what I received in our office, I don't believe, you can correct me if I'm wrong, but I don't believe that I've seen any of these documents or that they've been submitted to the AHO unless we misfiled them somewhere. So I just wanted to check in on that status, because I think the next step here would be to mark them as exhibits and submit them so that all of the parties can see what we're talking about. And then I will make respond to a formal motion to move them into evidence, and I can see if there's any objections to moving those into evidence. I will turn to you first, Mr. O'Brien, just because I believe your office submitted the stipulation, but does this process make sense to you?
That makes sense to me, Ms. Kinsey. I think we were holding off, making sure you were okay with the stipulation, but we would be happy to submit the various documents, mark them as exhibits, and then we will move them into evidence at the conclusion of our case. And if there are objections, we can deal with those at the time.
Thank you, Mr. O'Brien. Are there any other concerns about that approach from anyone? Great. Then I'll move on to this request for official notice that was filed by KWBA also on April 25th, and it was a request for judicial notice, of 5 documents. And I think what I want to do now is bring that to all of your attention and ask whether there are any objections to the request for judicial or official notice from KWBA. And now I'm going to say I don't have the documents in front of me, so let me take a look at them. I know they were marked A, B, C, D, and E. Maybe Mr. O'Brien, can I turn to you and just briefly describe, I'm putting you on the spot, briefly describe the 5 documents so that I can take official notice of those documents?
Let me scramble to open my binder here quickly.
And if we need to come back to this, we can. We could also do this at a later time.
This is Sam Bivens. I do have this up and we can walk through these. I'll take the load off Mr. O'Brien for this one.
Great. Thank you, Mr. Bivens.
So Exhibit A is a judgment denying a petition for writ of administrative mandate for North Kern Water Storage District et al. V State Water Resources Control Board, case number S1500 CV 270613 NFT in Kern County Superior Court, dated June 21st, 2011, attached to which is also another Exhibit A entitled Nature of Proceeding, Final Ruling on Petition for Writ of Mandate. That is judicially noticeable under Evidence Code Section 452D as a record of the court of this state, as is Exhibit B to the request for official notice, which is North Kern Water Storage District et al. The State Water Resources Control Board, dated April 18th, 2013, Court of Appeal case, Westlaw citation 2013 WL 1682466. Exhibits C, D, and E are judicially noticeable under Evidence Code Section 452C as administrative records, reports, and acts of the state. And those documents are the Buena Vista Water Storage District's application number A031675 with the State Water Resources Control Board Division of Water Rights, dated August 22nd, 2007. Exhibit D is the Kern Water Bank Authority's application number A031676, dated September 26, 2007, And Exhibit E is the certified stenographic recording of the proceedings and testimony that I believe led to decision 1196. And I will also represent that we subsequently learned that that stenographic transcript, I believe, is also already been admitted into the record as Exhibit North Kern 49.
So considering that North Kern 49 has already was admitted to, well, it was admitted to the evidentiary record in phase 1A, if that is correct, but has not been considered or admitted into phase 1B. So for purposes here, Mr. Bivens, does it seem appropriate? We're considering it admission of that recording or transcript for purposes of phase 1B. Is that the correct understanding?
Yes.
I'm trying to think of an organized way to do this, because I do wonder if some of the other parties, maybe not, but if the other parties want to move their applications into the evidentiary record for this proceeding, in addition to the two that you've included in this list. So I think let's hold on this, admitting these into the, I mean, I think certainly for the court decisions, official notice may be appropriate. But I just want to give everyone a little more time to think about whether there might be additions to this list that are appropriate, that we want, that should be in evidentiary record for phase 1B. So let's, I'm sorry, can we return to this issue at the end of KWBA's presentation of evidence, when we look at the remainder of your exhibits? And I'll address, and we'll formally address the issue at that time, and that will just give us a little more time. Does that make sense, Mr. Bivens?
Yes, it does. Thank you, Ms. Kennedy.
Okay. And then I am, Mr. Jacobs, don't worry, I'm going to give us a break before we roll into case in chief. But I just wanted to note for all of us about my understanding of the order of proceeding today. First, we're going to hear opening statements from KWBA and then presentation of the summaries of written testimony by their witnesses. I am planning on holding cross-examination immediately after the summary of each witness's written testimony, unless down the line in this proceeding, unless there's a good reason for us to cross-examine witnesses as a panel. But just as a standing presumption, I will hold cross-examination after each witness. So we will start with Dr. Milton. Well, I'll let KWBA decide. So, but it seems logical that to assume that we'll start with Dr. Miltenberger. And then afterwards, I wonder if it makes sense for us to consider any remaining evidentiary motions with respect to his testimony, because it'll be fresh in our minds, but we can think about whether this makes sense once we get to the end of his testimony. And then once we have completed, heard from all of the witnesses and completed cross-examination, then I'll consider a motion to move the remaining parts of KWBA's exhibits into the record, and we'll deal with any remaining objections. After that, we would turn to Buena Vista's opening statements and witnesses, but I think it's unlikely we'll get that far today. You can tell me if I'm wrong. So I think that sets us out for the day. Are there any other comments before? What I'm going to do is suggest we take a break. I know it's early, but we'll take a brief break. You'll have a chance to regroup, all of us, as to what we've discussed so far. But does anyone want to raise anything before we take a 15-minute break?
I have one item, Ms. Kenzie, if I.
Yes, Mr. Bivens.
This is in response to the supplemental objections that Mr. Pizarro's office filed yesterday. I just wanted to alert you that we also filed responses, short response to those supplemental objections around 8:30 this morning. And I hope when you consider Mr. Pizarro's objections that you'll also consider ours.
Thank you, Mr. Bivens. I had not seen that, so thank you.
Ms. Kunze, this is Colin Pierce again for City of Bakersfield. I just have a housekeeping question, and because
Please.
we're scheduled to be in hearing for the next 7 days, and to the extent I may need to schedule things like phone calls with other clients, that type of thing, I would just like to get a sense of your schedule for the next 7 days, like, you know, when you expect to take a lunch break and how long you expect to go each day, for example.
I would expect, what I'd like to do is to push forward as we can, and hopefully we will not be, as much as I enjoy your company, we will not be meeting for the next 7 days. So I do plan to have somewhat of an aggressive schedule up front, and then as we get tired later this week, maybe we'll even take a few hours off for our own mental health and attention. So I am thinking we will schedule lunch breaks for an hour. I will not do less than an hour. We'll get at least an hour for lunch, breaking between 11:30 and 12:30, depending on how the testimony cuts off, and going for an hour. I would expect that at the end of the day, we'll break at a convenient time, but somewhere between 4 and 5. I do not expect to go past 5 p.m. And I think we can actually, what I'll do is I'll set 5 p.m. as a hard stop for all of us so that we know. So we will not proceed past 5 p.m. on any of the days. Does that, Mr. Pierce, does that help to some extent?
Yes, yeah, thank you very much. Yes, and I do know that there's, especially as with our hearing, it's important to be flexible and all that. I just wanted to get your general sense of timing. Thank you.
Right, how I do things. Anything else for now? All right, it's 9:48. Let's go ahead and reconvene at 10 o'clock. Well, let me give Mr. Jacobs a fair time to print and read a ruling, and everyone else. Let's reconvene at 10:05, and we will decide then whether there's anything else we need to address before we move into opening arguments by KWBA.
Ms. Kinsey, could I request half an hour from now so that we actually can take a look at the ruling? We'll be cross-examining apparently Dr. Miltenberger first. I'd like to understand what testimony of his is in or out.
That's fair. Let's give a half hour. Let's go to 10:15. That's almost a half hour.
Thank you.
Thank you for asking. I will see all of you at 10:15 after our break. Thank you very much.
Thank you.
All right, it is 10:15, so let's go back on the record and get started. I will pause before we move forward with Kern Water Bank Authority's opening statements. I will look to the room to see if there are any comments, questions, or other matters that we need to discuss, either related to the written evidentiary ruling or anything else before we get started this morning. With that, I will turn to Mr. O'Brien or Mr. Bivens. If you would like, you may go ahead and make your opening statement, and then you may call your first witness.
Thank you, Ms. Kinsey. And before I get started, I'd like to ask Ms. Mullen to pull up 3 exhibits and not put them on the screen, but just to have them ready. KWBA 013, KWBA 248, and Buena Vista 200. Good morning, Ms. Kinsey, and I just wanted to start by thanking you and your staff for your hard work on this matter. This is a complex proceeding, as you well know, and it seems like we've conducted this hearing in a little bit of a compressed time frame. I think that's largely because you accommodated the request of the parties for some additional time at the front end, so we do appreciate that. The central issue in this phase 1B, as you know, is how much water is available for appropriation on the Kern River. But an important related issue, and this is called out very specifically in the hearing notice, and I'm referring to the January 12th, 2022 notice of pre-hearing conference. Very important issue is the validity and scope of claimed water rights in the Kern River system. And on page 5 of that hearing notice, the AHO states that in phase 1B, the AHO will consider evidence relevant to the validity and scope of claimed water rights in the Kern River system for the limited purpose of determining how much unappropriated water is available to supply the applicants pursuant to Water Code Section 1375, Subdivision D. The notice goes on to say this proceeding will not be an adjudication of water rights and is distinct from the statutory adjudication process authorized by Water Code Sections 2500 et sec. And then the notice cites to State Water Board Decision 1642, a 2001 decision. So the board or the AHO has thought carefully about the scope of this hearing, and the scope of this hearing is carefully articulated in the hearing notice. That's important as we move into the substance. What I'd like to do in my opening this morning is to briefly summarize the key evidence we'll be presenting in our case, and then to briefly discuss some of the evidence we'll hear from the other parties. Key fact number 1 in our case is the fact that the State Water Board has already determined that water is available for appropriation on the Kern River. I think the language that's used in the order is some water available for appropriation. So really the issue in this proceeding is how much and under what conditions. That determination in the 2010 orders was made based entirely on evidence presented by Daniel Easton of MBK Engineers. He was an engineer that was jointly retained by a number of the parties that are appearing for you today, including my client, Kern Water Bank Authority, including Buena Vista, including North Kern, including others. And what Mr. Easton's testimony showed is that there was water available on the Kern River in wet years in excess of existing rights. And he says that in his testimony, and that statement is picked up in the State Water Board's orders. It's this methodology that Mr. Easton used, which was based primarily on flows to the intertie in excess of diversions by senior right holders, that Ms. Boissevain utilized in connection with her supplemental water availability analysis, which I'll talk about in a moment. Key fact number 2 is that there is no credible evidence in this record that the scope of Buena Vista's pre-1914 right is 568,000 acre feet per year, as Buena Vista's general manager, Mr. Ashlock, asserts in his written testimony. The case law is quite clear that it's the intent of the appropriator at the time of the appropriation that is controlling for purposes of determining the extent and scope of the appropriation. In this case, Dr. Scott Miltenberger will testify that there was no plan of development in existence in 1914, or even in the few years following that a plan of development did not come into existence until the late 1920s, when there was discussion about the formation of Buena Vista as a district. We heard, or we will hear from Mr. Ashlock in his testimony about what he calls historical conjunctive use practices. But nowhere in the record is there any testimony that such conjunctive use practices were occurring in the time period around 1914 or before, or even shortly thereafter. Ms. Mullen, I'd like to pull up KWBA 13, and if you could go to PDF page 10, please. I think it's at the bottom of the page, Ms. Mullen, where I'm. Yes. So at the very bottom of this PDF page, there's the statement, and this is from 1920. This is these are the working papers of Harry Barnes, an engineer who later was involved in the preparation of Bulletin 9, which we'll hear more about. But in 1920, Mr. Barnes stated, underground water as a source of irrigation supply has not been developed in this territory. A number of artesian wells are found on the Miller and Lux. If we could move over to the next page. On the Miller and Lux ranches, but these are for supplying water to stock, and other wells are for domestic use only. It is not known whether dependable pumping supplies can be obtained under this area, but it is understood that investigation to determine this is being undertaken by Miller and Lux. Of the water already developed, the quality is variable. Some is alkaline and barely potable. Other from the deeper wells often contain sulfur, while still more seems without any objectionable features for either domestic or irrigation use. So there is simply no evidence in the record, notwithstanding Mr. Ashlock's description of historical conjunctive use practices, that conjunctive use was an intended use of Kern River water at the time of the establishment of this pre-1914 water right. You will hear testimony this morning or today from Dr. Jeff Davids. Since there is no data available showing the precise amounts of water being used by Miller and Lux circa 1914, Dr. Davids has prepared an analysis, a very conservative analysis, as he'll describe it, that establishes a range for what that use was. He concludes that the upper ranges of theoretical diversions within the current Buena Vista service area as of the end of 1914 was between 234,800 and 352,700. Due to the very conservative nature of Dr. David's analysis, as he will describe, it's our position that the lower end of that range, the 234,800 number, is the more accurate figure as a starting point, and I want to emphasize as a starting point. Why is it important to consider the scope of Buena Vista's and the Lower River right in this proceeding. I'd like to ask Ms. Mullen to pull up KWBA 248, slide 21. This is from Ms. Boissevain's PowerPoint that you'll see later. Now, I will say at the outset that the data represented in this diagram does not in all cases include water stored at Isabella, because that storage was not included in the reporting that Buena Vista did to the State Water Board in its statements of diversion and use. But the important thing about this figure is the trend. Now, if you look at what's happened, and this is in wet years, since Isabella was constructed in 1954, Buena Vista initially reduced its diversions in wet years. But in the more recent past, following the 2010 State Water Board orders, there's been a significant increase in Buena Vista's diversions. In 2017 is clearly the outlier. So the reason it's important to consider the scope of Buena Vista's right in this proceeding is what we don't want to end up with is a determination by the water board that there's a certain amount of water available for appropriation, but then have Buena Vista continue to fill the balloon, so to speak, and expand the scope of its water right as it has done in recent history.
Ms. Kinsey, I'm going to object at this point. You just stated approximately 45 minutes ago that this is not a proceeding to adjudicate water rights. Mr. O'Brien just stated they do not, the Kern Water Bank Authority's position is that Buena Vista's past diversions are not justified and that future diversions would not, above their calculation of the right, would not be justified. If this proceeding is to cap Buena Vista's water rights, it is a violation of fair hearing and due process. You just repeated 45 minutes ago that is not what this hearing is about.
Thank you, Mr. Becerra. Your objection is noted and overruled. I don't know how to be any more clear about this distinction, but maybe I'm not doing a good job. But this proceeding is not going to impose limitations in and of itself on the exercise of Buena Vista's diversions and use of water, or prohibit in any way Buena Vista from diverting and using water. This is a proceeding to consider how much water is available for appropriation. I think Mr. O'Brien's arguments are relevant to that subject matter to the extent, but with the caveat that it's limited to the scope of determining the amount of unappropriated water available to supply these applications that are before us. And I understand Mr. O'Brien's arguments here to be made in that context. I will turn this back to Mr. O'Brien. You may either proceed, or you can address if you have any comments additional to Mr. Becerra's objection, or you may go ahead and proceed with your opening argument.
I won't respond to Mr. Becerra's legal arguments. This is an opening statement. I'll focus on the evidence. Thank you, Ms. Kinsey. I will ask Ms. Mullen to pull up Buena Vista 200, page 19, paragraph 51. This is Mr. Ashlock's testimony. So a legitimate question that might be asked is why would Buena Vista increase its diversions as it has in the recent past, as we saw in the bar graph a moment ago? The answer really lies in the testimony of Mr. Ashlock, Buena Vista's general manager. And in paragraphs 51 and 52 that we'll look at on the next page, he explains that when he joined Buena Vista in 2013, let's stick with 51 for now, Ms. Mullen. Thank you. it had a number of capital expenditures, capital improvements it was looking at. And it was looking at the possibility of issuing bonds. Now, if we could flip over to 52. And then he says in paragraph 52, also in 2014, however, Buena Vista realized that it had a one-time opportunity to obtain, without taking on nearly so much debt, the financing necessary for the capital improvements the district needed to continue our historical conjunctive use practices with the significant conversion of crops. Pistachio trees do not provide a harvestable crop for 8 years after being planted, and for the first 3 years only demand about 1 acre-feet per acre of water. Buena Vista therefore had a short window of years during which it could transfer water to generate significant revenue to support the necessary capital improvements. So what's really going on here, and this is also reflected in the environmental impact report prepared by Krieger and Stewart for Buena Vista, that's included in our exhibits, is Buena Vista pivoted in approximately 2008, 2010, 2013, that time period, and it made a business decision to transfer water from the Kern River and maximize its revenues. And that really illustrates and provides very clear evidence for the reason for the facts that we're going to hear about in this hearing. I'd like to now turn briefly to the supplemental water availability analysis that you'll hear about. This will be from the testimony of Ms. Boisevane. That document, as you know, was in response to a request that came from the Division of Water Rights, Mr. Moody and Mr. McCarthy. In their depositions, I think they made it very clear that they had no opinions about the validity of the approach that they suggested in the correspondence that they sent to the parties. They hoped that the parties would cooperate and come up with a joint approach. That did not happen. Kern Water Bank Authority prepared its water availability analysis through Ms. Boisevane, which showed that substantial amounts of water available on the Kern River during wet years. I believe the upper amount is about 664,000 acre feet, which is from 1983. Ms. Boisevane's methodology is essentially the same methodology that was used by Mr. Easton and embraced by the Water Board in the 2010 orders. The competing analysis was submitted by several of the parties involved in this proceeding. We call it the joint WAA. You'll hear testimony from Mr. Young and others in defense of that approach. But the important thing to keep in mind about the joint WAA is that it really fails the test of reflecting hydrologic reality. For example, under the joint WAA, there was 135,000 acre feet of Kern River water shown to be available in 1983, but the actual flows, and these are the actual observed flows in the river that year to the intertie, was 664,000 acre feet. The joint WAA is simply not credible because it does not reflect observed hydrologic reality. Finally, you'll be hearing a lot in this hearing. In fact, we've already heard this morning about decision 1196. If you have not had a chance yet to review the hearing transcript from that proceeding, Ms. Kinsey, I commend it to you. It's really what I consider high kabuki theater in the field of water rights, because you had essentially a number of parties that walked into that hearing room with a preconceived settlement in mind, and then they proceeded to present their positions on the record, and the board ultimately adopted their positions. There was no cross-examination. There was no litigation of the issue of the scope of the Buena Vista water rights or any other water right. And so to come into this proceeding and argue that that decision should have some evidentiary weight or conclusory effect in this proceeding, I think is not only contrary to law, but it's contrary to common sense. And the last point I'll make is, as you know, Buena Vista has filed its own water right application, as have other parties. In August of 2007, it filed an application to appropriate 180,000 acre feet per year by direct diversion and 520,000 acre feet per year diversion to storage. So it's seeking a total right of 700,000 acre feet per year. I would submit that that is the correct process that should be followed here if Buena Vista or anyone else in this proceeding wants to increase their water use on the Kern River. They need to go through the appropriation process and submit themselves to the jurisdiction and oversight of the State Water Board. Thank you.
Thank you, Mr. O'Brien. I do have a question for you that I think will be helpful for me to just give a roadmap of where we're going. And you may have addressed this. I mean, I read your opening brief and to some extent, but just to make it very clear to me, would you address what you understand the relationship to be between the evidence that you'll be presenting related to the scope and validity of Buena Vista's water right and the water availability analysis that you're advocating in favor of, that was, as I understand, conducted by Ms. Boisavain?
Yes, our position, and this is consistent with the statements made by Daniel Easton in his testimony for the 2010 orders, is that the water that was left in the Kern River in those wet years and that flowed to the intertie is surplus to the rights of the other parties on the system, including Buena Vista and including the lower river right.
And would it be accurate to characterize Kern Water Bank Authority's application to appropriate water to be an application to appropriate water that, at least historically, flowed into the intertie and was in excess of demands on the system?
Yes.
Okay, thank you, Mr. O'Brien.
You're welcome.
With that, I will turn to you to please call your first witness.
Yes, Mr. Bivens is going to present Dr. Miltenberger.
Thank you. Good morning, Dr. Miltenberger.
Good morning, Ms. Kinsey.
Will you please raise your right hand and I will administer the oath? Dr. Mittenberger, do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may proceed, Mr. Bivens.
Good morning, Dr. Miltenberger.
Good morning, Mr. Bivens.
Is Exhibit KWBA 001 a true and correct copy of your written testimony in this matter?
Yes, it is.
Are there any corrections you'd like to make to that testimony, Dr. Miltenberger?
There is, yes.
What are they?
Well, specifically, I'd like to correct the citation for the report prepared by J.B. Lippincott in September of 1919. It's incorrectly cited as having come from the Water Resources Collection and Archives. This particular report came from the Bancroft Library.
Thank you. Ms. Mullen, could we pull up Exhibit KWBA 024, please?
Oh, and Mr. Bivens, actually, just to be absolutely clear for the record, the first instance of this erroneous citation appears on page 16 of my written testimony, footnote 44.
Thanks for that clarification. Dr. Miltenberger, is exhibit KWBA 024 a true and correct copy of the PowerPoint slides you submitted as an exhibit to your written testimony?
Yes.
Would you please summarize your written testimony for the hearing officer?
Yes, but before we begin, Ms. Mullen, may we also, or would you please also pull up the following exhibits to have at the ready? KWBA 03, KWBA 06, KWBA 13, KWBA 16, and KWBA 17.
She's quiet but fast, so she probably has that at the ready.
Great, thank you, Ms. Mullen. Ms. Kinsey, allow me to introduce myself. My name is Scott Miltenberger. I am a professional consulting historian with JRP Historical Consulting in Davis, of which I am also a principal. I have my doctorate in U.S. history with concentrations in environmental, cultural, and urban history from the University of California at Davis. I've been with JRP for 15 years, working on providing historical research and analysis on environmental and natural resources issues. Much of my work has been in land and water use history in the American West and California especially. I've qualified as an expert historian and given expert testimony in state and federal court, most recently in the US Supreme Court, original action, state of Texas versus state of New Mexico and state of Colorado. Now, maybe, Ms. Mullen, we go to the next slide, please. Thank you. So, Ms. Kinsey, the history of the Kern River Basin is rich and complex, filled with many colorful characters, many significant events, public and private entities that continue to exert influence in California today. The focus of my work, though, was on the historical record of land and water use within the present Buena Vista service area, or what would become the Buena Vista service area. Looking at the period from the late 19th into the late 20th century. I charted continuity and change across 5 time periods, which are identified on this outline here as items 2 through 6. Separately, KWBA 4, the timeline I have, also identifies some of the significant events over the course of these 5 historical periods. I also provide separately the historical context for the Lower River rights that were set forth in the 1962 agreement. In my presentation today, I have included at the very end a summary of key opinions. But for this oral summary, I'd like to focus on 4 essential observations to be drawn from the historical record. First and foremost, the Kern River is and was capricious, particularly before the advent of upstream storage at the Isabella site. Floods are as important to the story of land and water use in the late 19th and early 20th century as are droughts. And in the particular area in which Buena Vista emerged, land reclamation was an essential first step, and management of flood flows was essential to ensuring those lands were cultivable. The fact that floods also necessitated the construction of works to manage those flows, most notably a flood channel that passes along the west side of what today is the Buttonwillow service area of Buena Vista. Prior to Isabella, the only regulation in the basin was Buena Vista Lake Reservoir. That's the first point. The second observation is that the livestock operations of Miller and Lux define land and water use in the area prior to 1914 and well into the 1920s. Miller and Lux, headquartered in San Francisco, was the premier, may have been the premier agribusiness of the 19th century. It had vast land holdings to support its livestock. So when looking at the historical record, it's important to be attentive not only to time, but also to place, to location. Miller and Lux leveraged water within this area for their stock raising. And they practiced flood irrigation in order to achieve the results required to sustain that stock. The historical record, though, reveals that Miller and Lux could only use a portion of the Kern River water supply within the Buena Vista service area lands. The third essential observation. The singular focus of Henry Miller, the company president until 1914, was on livestock. And it's maybe worth noting, just a matter of interest, Ms. Kinsey, that Henry Miller reportedly, in one episode, dressed 16 hogs, slaughtered and dressed 16 hogs in the time it took other butchers to do 3. He was a man committed to livestock raising. And therefore, there is more continuity than change in the area. There's no evidence of a plan prior to the 1920s for a reorientation of the land and water resources controlled by Miller and Lux, a plan to shift away from livestock. The fourth essential observation is that gradual changes came in the wake of the district plan in 1928. But those changes accelerated with Isabella. Those changes included increased cotton production, more supplemental groundwater use, and the contracting for state water project water. And what is the Buena Vista service area today? Ms. Mellon, would you please pull up KWBA 3? Thank you. This is a map of the current Buena Vista service area overlaid on an aerial image. The Buena Vista service area actually includes sort of 2 sub-areas, 2 sub-service areas. The largest of these, Ms. Kinsey, is the Button Willow service area, identified here in green. A particular note to this, and it'll be, I think, an important geographical point as we move through the historical record, is Wasco Road, which is at the very top of the Button Willow service area as depicted here. A second service area is located to the east of the historical Buena Vista lake bed, the Maples Ranch service area. Both of these areas emerged out of swamp and overflow lands that were at the bottom of the Kern River Delta. Ms. Mellon, may I please have slide number 3 from my PowerPoint. So, Ms. Kinsey, this is a map prepared by William Hammond Hall, the state engineer in the late 19th century. It was prepared on the basis of a statewide investigation he made to document irrigated development within California. It's a particularly well-known map from 1886. And unfortunately, the quality of this image doesn't do it justice. So Ms. Mellon, may we shift gears or shift over to KWBA 6? Thank you. And just, Ms. Mellon, there may be some areas that I'd like to zoom in on, but I'll do my best to describe those for you. So, well, as a matter of fact, let's begin with that. Ms. Mellon, would you please highlight the area located just above the ridge of hills, the teal area? It's kind of triangular in shape above Buena Vista, like a little more to the, I guess would be to my left, or I guess maybe you're right. All right, this is fine. Oh, there we go. That's good. That's good. So a couple things I'd like to call out for your attention, Ms. Kinsey, from this map. First of all, the areas shown in that kind of teal color denote irrigated areas circa 1886. Also shown on this map are swamp and overflow lands. So the Kern River rises in the Sierra Nevada and flowing out flows into a broad plain. The lands at the very bottom of this delta were overflowed, were swamplands. And that constitutes the majority of, well, it constitutes the whole of the Button Willow service area today and the Maples Ranch area to the east of the lake. This map gives some sense of the context for the Lux v. Hagen litigation, because the area that's delineated in a kind of more greenish color within the Button Willow service area, that's roughly triangular area. And Ms. Mellon, maybe we can get in a little bit closer on that, just above that ridge of hills towards the center of the screen. Great, that's perfect. That roughly triangular area, Ms. Kinsey, was the area that Hall identified circa 1886 as being irrigated by facilities developed by Miller and Lux and affiliates. That area comprised approximately 3,600 acres in alfalfa. And you can see when compared to all the other lands upstream, was only but a small amount of the total irrigated acreage in the area. A couple other things I'd like to call out for your attention that are important, again, when reviewing the historical record, is you'll notice along the left-hand side of the khaki-colored area, that olive khaki-colored area that delineates the swamp and overflow lands, that out of which the Buena Vista Water Storage District emerged, and the Button Willow service area in particular emerged. You'll note a canal, the Kern Valley Water Company Canal, flowing to the west. And I want to talk a little more about that in a moment. It's a little more difficult in this resolution to see, but on the east side of that roughly triangular area is the East Side Canal, an irrigation structure that provided water to the area. If we may scroll down a little bit more, Ms. Mullen, there's a few other things I want to point out for Ms. Kinsey's attention. We scroll down actually to the Buena Vista Lake itself, as depicted in 1886. That's great, thank you. So following the Miller-Hagen decision, excuse me, the Miller-Hagen agreement, a levee was erected along the east side of Buena Vista Lake. That levee not only enabled the lake to store water, but also to provide for the reclamation of lands to the east, lands between Buena Vista Lake and Kern Lake, as depicted here. One note about what the understanding of the hydrology was at the time of this period, as detailed by William Hammond Hall, is that the waters of the Kern River would flow down into this delta and would back up into Buena Vista Lake and Kern Lake. They would also flow northward through the Buena Vista Slough, debouching into Tulare Lake when the river was in high flood. And so if we could scroll a little bit higher up on this map, Ms. Mullen, I just want to show that for Ms. Kinsey's orientation. Yes, we could scroll, if we move the map also a little bit more to the right as we're head up to Tulare Lake. That's great for our purposes. Thank you, Ms. Mullen. So, Ms. Kinsey, the waters of the Kern River would flow through the Buena Vista Slough, as I indicated earlier, and would find themselves all the way to Tulare Lake, passing beyond Wasco Road, or what would become Wasco Road. And I'll get into more of that in a little bit. Ms. Mullen, when we go back to my PowerPoint, go to slide 4, please. Thank you. So this is a hand sketch made by Hall in 1885 as part of a handwritten manuscript that was ultimately contemplated to be turned into a published report. There's a couple of things I'd like to identify for your attention, Ms. Kinsey, that are very relevant to appreciating land and water use within the history of land and water use within this area. First and foremost, you'll notice on the left side of this illustration, the notation West Side Canal. It's important to understand that the West Side Canal that's identified here is not, in fact, the West Side Canal that we understand today. Rather, this structure is what was identified on the previous map as the Kern Valley Water Company Canal. It was functionally a flood channel and was one of the first works, in fact, the first work developed in this area to facilitate reclamation and ultimately flood control. The West Side Canal, as we understand today, was actually heads further downstream from this particular area that's illustrated here. I contrast this West Side Canal, the Kern Valley Water Company Canal, or what you may hear me call throughout my testimony is the flood channel, with the East Side Canal, which is depicted here on the right side of the illustration. One gets some sense of the size of these structures by the parallel lines that delineate them. The West Side Canal, or the parallel lines, are wide, and the tick marks you see on either side of those solid lines identify levees. The East Side Canal contrasts to the Kern Valley Water Company Canal, or the flood channel, is much narrower because the East Side Canal was intended exclusively for irrigation. It's very easy to mistake the flood channel for the West Side Canal. And in a number of historical maps that have been produced in the course of this proceeding, it's important to pay attention to the flood channel relative to what is today the West Side Canal. In Hull's investigation, he also laid out a number of features of land and water use in this area, features that persisted well into the 20th century. Hull described a system of irrigation that, while inefficient, was economical and suited Miller and Lux's purposes. Flood irrigation was practiced within this area well into the 1920s. The typical practice of Miller and Lux, as detailed by Hull, was to create checks, small levied up areas, approximately 8 to 10 acres in size, into which water was introduced. Crops such as alfalfa were cultivated, or these areas were led to pasture. Of importance, as Hull notes, was drainage. The soils of this area, in Hull's estimation, did not readily percolate water. So drains were required to move water through this area. All right, we have the next slide, Ms. Mullen. Now, as I spoke of earlier, Ms. Kinsey, floods are just as important to the story of land and water use prior to Isabella in the Kern River Basin. George Baldwin, in an engineering memorandum for the California State Water Commission, identified some of those flood and drought periods. Of droughts, he identified the period from 1898 to 1900 and 1912 as drought years. And I should mention before I get too deep in this is that Baldwin's memorandum was prepared in 1916. Baldwin also identified the years 1893, 1906, and 1909 as years of high water and of floods. It's these last 2 years that I'd call your attention to, Ms. Kinsey, and they're going to be important as I move forward in the historical record. Newspaper reporting of the 1906 flood in particular noted that those waters could not be diverted into Buena Vista Lake, nor could they be diverted to the land. In fact, quite a bit flowed through the Miller and Lux system as had been developed in 1906 and went past Wasco Road, ultimately finding their way into Tulare Lake. That's an important piece that I'll also return to later in my presentation. May we have the next slide, Ms. Mullen, please? Thank you. So following the Miller-Hagen agreement, Miller and Lux developed works to divert Kern River water. By the late 19th century, water could be turned in three directions. Water could be turned southward into Buena Vista Lake Reservoir. Water could be turned to the north, as it's sometimes referred to supply lands within the Buttonwillow service area. Or water could be bypassed through that Kern Valley Water Company canal, through the flood channel. The image here is a photograph from 1920 of the most significant infrastructure work developed prior to 1914 by Miller and Lux. This is the concrete weir. Now, the concrete weir was located within the flood channel. Now, in this identification here, in this caption, it's identified as being in the outlet gate, but it's more appropriately understood to exist at the point where the outlet canal from the Buena Vista Lake Reservoir met the flood channel. Because with this concrete weir, which replaced an earlier timber structure, and this concrete weir was built between 1911 and 1912. Water, when those gates were closed, water would back up from the flood channel and into the west side canals, we understand it today, and the east side canal. When the river was in flood, or when there was too much water to be stored in the lake or to be diverted to lands, those gates would be opened and that water would pass down the flood channel. The concrete weir had an estimated capacity of 2,500 CFS, which gives you some sense of the capacity of the flood channel itself. May we have the next slide, please, Ms. Mullen? Thank you. As I discussed in my written testimony, estimates of acreage, of irrigated acreage, within the future Buena Vista service area varied. This slide is of the cover of one of those studies. This study was prepared by C.E. Grunsky in 1898. Grunsky had formerly worked for Hammond Hall. He had been part of his team. This particular work was prepared as Grunsky was in a consulting capacity to the USGS. Like Hall, he identified, well, persistence of practice. He identified flood irrigation as being the principal mode of water delivery. And he identified 20,000 acres of alfalfa irrigated at the head of the Miller and Lux canals, which would be at the very bottom of the Buttonwillow service area today. Other reports by the USDA or USDA engineers into the early 20th century identify other estimates, but continue to attest to persistence in practice and the dedication of lands to livestock raising. May we have the next slide, please, Ms. Mullen? Two of these reports are depicted here. On the left-hand side is a report prepared by F.W. Roding in 1911, based upon work in 1909. And the report prepared by Sidney Harding and Ralph Robertson in 1912. Roding identified for this particular area an irrigated acreage of approximately 63,000 acres. This is the largest single independently reported estimate of the acreage irrigated within this area. But it's important to note that it would have encompassed lands outside of the Buena Vista service area today. The Harding-Robertson report or study identified more of a range depending upon the area of analysis. For the Buena Vista Slough area, which today comprises the Buttonwillow service area, or a considerable portion of the Buttonwillow service area, Harding and Robertson identified 40,000 acres as being irrigated. For the larger Kern River area, they identified 50,000 acres as being irrigated. Harding and Robertson, in particular, again, identified these same methods of irrigation, flood irrigation, identified the same types of cropping that one found, first identified, by William Hammond Hall. May we have the next slide, please, Ms. Mullen? In my opinion, Ms. Kinsey, the most reliable approximation of the amount of land irrigated by Miller and Lux comes from the work that was published in 1921 as Bulletin Number 9, which is depicted here on the right. Bulletin 9 was in fact authored by Sidney Harding, the same Sidney Harding who prepared a report with Ralph Robertson back in 1912. Harding was acting in a consulting capacity to the California Department of Engineering at the time. He was assisted in this work by Harry Barnes, whose own report, a TypeScript report that ultimately provided information that found its way into Bulletin 9. That report is here on the left. Bulletin 9 is the most thorough assessment that I found in my research of irrigated acreage and development within the Kern River Basin as close in time to 1914. As I discussed in my written testimony, it identified approximately 43,600 acres as being irrigated with an average annual supply calculated by the bulletin of 150,000 acre feet available at the second point of measurement. The focus of the study was on the surface supply of Kern River. And I think we have some indication of that from the work and why they did it, some indication of the work by Harry Barnes. So Ms. Mullen, would you please pull up KWBA 13? You could stay on this same page. Actually, just scroll a little bit above. Oh, I'm sorry, I might say scroll down. Thank you, that's perfect. This, Kinsey, you already saw in Mr. O'Brien's opening statement, this quote, so I won't belabor it, but I'll just simply note that this was a component of the study, that there was no underground water as a source for irrigation supply has not been developed in this territory, according to Barnes. The work of Bulletin 9, though, could not have been accomplished without the assistance of a number of water users, including Miller and Lux. So, Ms. Mellon, would you please turn to, or would you please, with the same exhibit, go to PDF page 60? Can you scroll up a little bit? Thank you. So, Ms. Kinsey, this acknowledgement appears at the end of Barnes's TypeScript report, and I'll just read it for the benefit of the record. Acknowledgements are made and thanks are due to local officials of Miller and Lux Incorporated for furnishing information granted and courtesies extended by them during the course of the investigation, whose results have been outlined in the foregoing being the Barnes report itself. May we go back to slide 9, Ms. Mullen?
Ms. Mullen, Brian Becerra for Buena Vista. I have a question. Are we observing time limits in the presentation of summaries of testimony? I thought we were.
I believe you're talking to me, not Ms. Mullen.
I'm sorry. Yes,
that's okay, Mr.
My
Becerra.
apologies.
I was considering the same thing, but maybe remind me, Dr. Miltenberger, how many more slides, or can you give me an estimate of how long we are? Let me just preface this with saying, I find your summaries here quite helpful, but I do want to move this along. Dr. Miltenberger, do you have an estimate of how many more minutes you have to summarize your testimony?
Ms. Kinsey, I did not know precisely when I began. I would say that the number of slides I have, I would estimate an additional 15 minutes. I might be able to do that somewhat shorter.
So, Mr. Becerra, your objection here is noted. I realize this, but I am finding this to be quite helpful. I will certainly extend the same type of courtesy to your, and let me pull up my screen. I can't see you, Mr. Becerra, which is not your problem. It's my problem. There we go. Now I can see you.
Well, Ms. Kinsey, I'm going to have to object. I mean, one of your hearing notices expressly states there's limits on the parties. We have prepared our witnesses to stay within their limits. Dr. Miltenberger, I think, has consumed about 20 minutes so far. He's got another 15, apparently. And so it is not frankly inappropriate solution to say everyone can just have more time. Our witnesses have been prepared to stay within their limits.
Ms. Kenzie, if I could respond to that briefly, I believe that the time limits were overall for the presentation of each party's case in chief. I believe it was 2 hours for Kern Water Bank Authority. And my understanding from that was that we were free to divide the witnesses' presentations within that 2-hour limit as we see fit. And I do think, for the record, that to the extent we consume more time than that, the way to cure that issue would be to give other parties more time as well. But I think we'll stay within the overall time limits that you prescribed.
Thank you, Mr. Bivens. Thank you, Mr. Becerra. That is my recollection, although I don't have my ruling in front of me, that I did give the parties 2 hours total and that they could apportion this among their witnesses appropriately. Does that contradict? I don't know if Mr. Becerra, you have this in front of you. Does that not fit with your understanding?
My recollection is that yes, we were allocated 120 minutes cumulatively. I believe the amended notices of intent to appear stated how long each witness would use. I don't recall offhand how long Dr. Miltenberger's estimate was.
That's fair. So, well, what we'll do is we will keep track. Time is important, and you're right, Mr. Becerra. We want this to be fair, and I don't want this to go on forever. I do note also within my discretion that to the extent I find the summaries helpful, I do want to continue to hear that. But let's keep track of the total for, I know we've had this little interlude, but the total for Dr. Miltenberger's time. And then I will do my best to make sure that this is fair and efficient for everyone and that we stay within our time limits. And I will just ask Dr. Miltenberger to move this along, but effectively. And I appreciate your explanation. I particularly appreciate your explanation of some of the exhibits and the maps and things like that, because it helps me to connect the maps with the particular testimony. So your objection is noted. I won't say overruled, but we will keep it in mind, Mr. Becerra. Thank you, Dr. Miltenberger, you can proceed.
Thank you, Ms. Kinsey. So Bulletin 9 offered two key recommendations among many. It's a very detailed document. One was the formation of a district for the entire Kern River Basin, and the other was an endorsement of Isabella storage. And this second point, I think, the first point about the district is one of the more significant ones for the history of this area. Because beginning in 1915, Miller and Lux started searching for a way to subdivide and sell their lands with a water supply attached. By the early 20th century, Miller and Lux was no longer the dominant agribusiness it had been. It embraced the idea of a district, a water storage district, after failed attempts to achieve a similar union of land and water to assure lands that they sold had that water supply attached. Maybe we get slide number 10. Thank you, Ms. Mullen. So as I detail in my written testimony, Miller and Lux developed a proposal that was ultimately scaled down, in part because of the identified inadequacy of the water supply for all the lands in which the petition was encompassed. That recommendation was made based in part on an analysis prepared by Sidney Harding, one of the most knowledgeable engineers of the era and of this area. There's a couple things I'd like to highlight for your attention, Ms. Kinsey, about the 1927 district plan, which is sometimes referred to in the historical record as the Hyatt Report. First of all, Hammett calculated an average annual supply of 140,550 acre feet. That's one. Two, he identified an irrigable area of approximately 42,000 acres. And he further described or identified a water duty of 2.25 acre feet per acre, specifically identifying 2 acre feet per acre as having previously been adequate for lands within the area and for the types of crops being grown, which by the late 1920s encompassed not only alfalfa and grains that has been traditionally grown in the area, but also an increasingly cotton. One of the things I want to call to your attention, Ms. Kinsey, though, is an observation that Hammett made. Ms. Mullen, maybe please have PDF page 14 of KWBA 16. Thank you. And would you please highlight the area so we can see the third sentence in that first full paragraph, a little more center in the screen. Thank you. So the essential observation that Hammett made is embodied in this sentence here, beginning with while. Skipping down to the most relevant parts, Hammett identified 1906, 1909, and 1916 as years in which the amount of water available to the district, to the proposed district, would have greatly exceeded the needs of the district, and a large amount would have been wasted. Now, Hammett, as I discuss in my written testimony, proposed a number of works to increase the efficiency of the system for the district. But in Sidney Harding's estimation, what was proposed in the district plan was more a change in ownership and management than the development of any new supplies. One of the essential aspects of this plan, though, or to realize this plan, was an agreement that Miller and Lux entered into with the district in 1927. So, Ms. Mullen, may we please see KWBA 17? Would you please scroll down to paragraph 3 of this document? Now, Ms. Kinsey, appreciating that this is a legal document, I don't purport to offer a legal opinion about any of the import of the statements made herein. Rather, I would just call your attention to this paragraph, and in particular, that what I think is an essential part of the history of land and water use, that first call to the waters that Miller and Lux controlled was made to lands within the district. And that lands north of Wasco Road should only receive surplus water after all district requirements have been met, including the filling of storage reservoirs. And that's noted here about, let's see, 1, 2, 3, 4, 5, 6, I believe 6 or 7 sentences down, beginning with "it is the purpose." All right. Okay. May we go back to my PowerPoint, Ms. Mullen, and slide number 11? Thank you. So post-adoption of the plan, Ms. Kinsey, there was a gradual move away from the types of feed crops, alfalfa and grains, and a transition to more lucrative crops such as cotton post-1928. And by the 1950s, cotton was the principal crop within the Buena Vista service area. This change can be seen across an array of sources. 3 examples are presented here. The first is reports that were made by Buena Vista to the state engineer, reports that were bundled together with reports by other public districts in Bulletin 21, the Bulletin 21 series. In reports the district made to the District Securities Commission, which was the entity that oversaw the bond issued by Buena Vista to acquire the Miller and Lux and related works for the district purposes. And then finally, Federal Land Bank appraisals made by engineers who relied on data that Buena Vista provided to the district, but also undertook their own field examinations and interviews with, and interviewed district officials. In one thing I want to call your attention to, I discussed in my written testimony, is that the evidence indicates that not all the water that was available to the district could be used post the district plan. In
Ms. Kinsey, I'm going to object. Dr. Miltenberger is simply repeating now technical analyses from these documents. He just stated, was attempting to describe the analyses in these documents. All he's doing is repeating the opinions expressed by people who appear to no longer be alive. And he does not have the qualifications to be repeating the bases or contents of their technical opinions.
Thank you, Mr. Becerra. Your objection, I think there's something to say. I mean, in my evidentiary ruling, I did note that I appreciate the limits on Dr. Miltenberger's expertise, and that to some extent, discussion of the historical documents and the conclusion in those is appropriate to frame his understanding of the history and the events, but also that I would be considering those statements and the repetition thereof as not adding any technical expertise by him, because Dr. Miltenberger is not an engineer. So I understand that. I will say, I think I'm looking at a check on our time and the estimate for Dr. Miltenberger to move forward. I think your testimony is fairly self-explanatory in your written testimony on this subject matter. What I would do is encourage you to maybe proceed into some of your later slides where there may be, I think, other information that would be particularly helpful for us to hear, for me to hear a summary of at this time, because I would like to wrap this up in the next 5 to 10 minutes.
Of course, Ms. Kinsey.
Thank you.
And I'll just, to just complete my point, I'll just say that the 1952 report by Buena Vista, the District Securities Commission, report by the district simply notes that 211,000 acre feet was bypassed in that year. And this would have been flows that would have reached or potentially been available north of Wasco Road. And this speaks to the historical context I provide for the Low River Right later on. Moving on, Ms. Mullen, we have slide number 12. So, Ms. Kinsey, as I mentioned earlier, as I began, changes accelerated post Isabella, and these are charted once more against many of the same sources that I discussed just a moment ago. What I'd simply like to note is that these changes accelerated really with Isabella, because Isabella changed the river regime. In 1938, Buena Vista, along with other Kern River water users, made an appropriation for water through the state board process. Negotiations revolving around the administration of the Kern River waters took up a great deal of the 25 years, more than 25 years till decision 1196 and 1964. There's a couple of things I would just highlight for your attention, Ms. Kinsey. One is the 1962 agreement that was executed at this time, in which the administration of the waters of the Kern River were divided between an upper and lower group, with provision made for 32% storage in Isabella for Buena Vista. The 1962 agreement also set forth the Lower River Right, which I'll talk a little bit about the historical context for in a moment. The other agreement that I think is important to appreciate when looking at the history of land and water use in this area is the 1964 agreement, in which Buena Vista agreed with the Buena Vista Lake Reservoir Associates and with Miller and Lux to relinquish cell 3 of Buena Vista Lake Reservoir for storage, thereby freeing it up for cultivation. The finding in decision 1196 that there had been no showing of no unappropriated water. Well, in the wake of that, Buena Vista looked elsewhere for water. Groundwater, which had once been supplemental to the needs of the district, by the 1960s had become essential, and that's described in the M&L engineering report from 1967. That engineering report, though, recommended contracting for state water project water. By the mid to late 1970s, cotton remained king in the area, as detailed in this crop report from the Federal Land Bank. But traditional crops continue to be grown, including alfalfa and various kinds of grain. And in 1976, too, from this report, we see the beginnings of nut cultivation in the area. Just to be brief and to wrap up, I'd like to just say a little bit about the Lower River Right, Ms. Kinsey. So, Ms. Mullen, will we please go back to KWBA 16? We go to PDF page 7. Great, thank you. This is perfect. So, Ms. Kinsey, as I mentioned before, I do discuss the historical context for Lower River Right in my written testimony. But for the purpose of this presentation, all I really want to do is just highlight that in brief, the historical record indicates that those rights were historical flows that were surplus to Miller and Lux and ultimately the district's needs. They were waters that could not be stored in Buena Vista Lake Reservoir, and rather were waters that were bypassed around the district through that Kern Valley Water Company canal or flood channel, or found their way through the drainage system of the district north of Wasco Road. In the context of the Isabella negotiations, those lower river interests, principally Tulare Lake Basin Water Storage District and Hacienda Water District, were able to secure those flows. We're able to negotiate for those flows, which now would be captured in Isabella. But again, these were historical flows that would have reached a second point of measurement, but been unavailable to the district, or excuse me, I would say unavailable, would have passed through the district system north of Wasco Road. So just to sum up, Ms. Kinsey, the history of the Kern River Basin is very rich and complex, but I think there's 4 essential observations to be drawn from the historical record. One is the capricious nature of the Kern River, and that floods are just as important to understanding the story of the development of this area as there are droughts. 2, that the livestock operations of Miller and Lux define land and water use in this area well into the 1920s. There's more continuity than change in the area. There is no plan of development to reorient land and water resources in this area away from livestock prior to 1914. And that change really came with the district plan in 1927, changes that were gradual until the advent of Isabella in 1953. Thank you.
Thank you, Dr. Miltenberger. I appreciate that. And for you, Mr. Bivens and Mr. Becerra and others, I think I keep a rough estimate of timing on that. I think that was about 37 minutes, give or take. So we'll just keep that in mind for future presentation of testimony. At this point, it is 11:28. I will be turning to you, Mr. Becerra, first for cross-examination, but I will grant you the courtesy of asking you, would you prefer to begin now, or would you prefer to take our lunch break somewhat early and begin after lunch?
I think I can start now.
Okay.
I don't think anyone else is planning to cross-examine Dr. Miltenberger, but I offer, if North Kern or Kern County Water Agency would like to start, maybe that's a good way to use our time before lunch.
We could do that. I will look to the other parties. Are any of the other parties planning to cross-examine Dr. Miltenberger? Well, just please let me know that. That would be a good start. Mr. Jacobs?
I just have a couple quick questions.
Anyone else? Well, then maybe we'll do that. Mr. Jacobs, would it be okay with you if we started with you?
Absolutely.
All right, let's go ahead. You may ask Dr. Miltenberger your questions, and then I think likely we'll break for lunch after that.
Ms. Kinsey, actually, slightly before we begin, may I get a little more water?
Absolutely. Let's take a 2-minute break, grab what you need, and meet us back.
I had the spelling of Boisbane, Miss Boisbane or something.
Ms. Kinsey, while we're waiting, just a logistical matter, we lodged a number of cross-examination exhibits to our private FTP. I just want to make sure that they're available for use in cross-examining Dr. Miltenberger.
Thank you. Thank you for letting me know. And Ms. Mullen is listening. I'm sure she's on it right now. And we will make sure that once we reconvene after lunch, those are ready to go. So thank you, Mr. Becerra. And then I did hear from the court reporter a request to spell Ms. Boisavane's name. I'm going to turn to either Mr. Bivens or Mr. O'Brien, if you would. I don't have it in front of me. Would you please spell Ms. Boisavane's name for the record?
B as in boy, O as in Oliver, I as in Ivan, S as in Sam, S as in Sam, E as in Every, V as in Victor, A as in affable, I as in Ivan, N as in Nancy. Guess I should learn the military alphabet.
Thank you, Mr. Bivens. Affable is probably not in there, but
I don't think
maybe
so.
it should be. Dr. Miltenberger, are you hydrated or have hydration available to you, and are you ready to proceed?
I do, Ms. Kinsey. Thank you.
Thank you. I will then turn to you, Mr. Jacobs. You may proceed with your questions for Dr. Miltenberger.
Thank you. Dr. Miltenberger, are any of the opinions that you've offered today in either in your written testimony or in the oral summary that you just gave, based on evidence that is not found in the documents that you have submitted as evidence?
I might have lost you, but could you please repeat the question?
Is the entire evidentiary basis for the opinions that you've offered in this matter the historical documents that you have submitted as evidence?
Well, I haven't.
Objection vague as to submitted evidence.
I think, may I make a clarification? I'll do this, Mr. Jacobs. I think I understand your question, and I think Dr. Miltenberger probably does too, but to clarify that the question is whether or not the entirety of his testimony or whether any portion of his testimony relies on evidence or sources that are not within the exhibits that Dr. Miltenberger submitted to this office.
Correct.
So I'm following that, understanding that, there is materials that I cite, but what I have not produced as exhibits.
The materials that you've cited but not produced as exhibits, are those historical documents?
I would characterize them so, although of course history is broad and there's some, what's historical to one may be contemporary to another potentially, but I relied on documents that appear in the historical record.
Entirely.
I can't recall a document that I did not use that I would characterize as historical in nature.
Okay. No further questions. Thanks.
Thank you, Mr. Jacobs. Mr. Becerra, since that was remarkably short, do you care to proceed at this time?
Yes, I can get started.
All right, thank you. Go ahead, Mr. Becerra. We'll go forward. If you reach a point where you think it's an appropriate breaking point, even when we're a half hour in or so, please just let me know.
Will do. Good morning, Dr. Miltenberger. I'm Ryan Becerra. I am an attorney for Buena Vista Water Storage District in this matter. Do you understand that?
I do, Ms. Becerra.
And I'm going to be using the phrase Buena Vista many times. And when I do that, if it's just Buena Vista, I mean Buena Vista Water Storage District. Do you understand that?
I do.
Okay, thank you. Can we please pull up Dr. Miltenberger's testimony, exhibit KWBA1, and turn to page 23, please. Okay. And could we scroll down, please, further? I'm sorry, I may have made a mistake. It's PDF page 24. It's numbered page 23. There we go. Thank you very much. Dr. Miltenberger, on lines 7 through 9, you discuss how you reviewed materials at the Miller in the Miller and Lux archives at the Bancroft Library, correct?
Yes.
Is the Bancroft Library at UC Berkeley?
It is.
Approximately how many boxes of material constitute the Miller and Lux records at the Bancroft Library?
Oh, the collection is quite large. And some of the boxes are in fact more cartons as they're described. Some of them are oversized ledgers. It's a large collection.
Is it a couple hundred banker's boxes worth of material approximately?
I couldn't say for certain. I would have to take a look at the finding aid again, but I think it's easy. I think it's probably more than that.
Is the finding aid over 700 pages long?
It could be. I don't remember. I know I have a copy of it. I don't remember its exact extent.
Okay, I appreciate that. Is it at least a few hundred pages long, just the finding aid?
That seems correct.
Okay. Now on lines 7 through 9, and I have to apologize, the way Zoom is set up, I have to set the box up so it kind of covers some text. I apologize for that. It's a little hard for me to keep track of line numbers. On lines 7 through 9, you use the phrase plan or proposal of progressive development, correct?
No, I think it actually says on line 9, plan or proposal for progressive development.
Apologies, that's my error. That's what it states though, correct?
Correct.
Okay. When you reviewed the Miller and Lux corporate papers, were you looking for a single document labeled plan or proposal for progressive development?
No.
Okay. Who told you to use the phrase plan or proposal for progressive development?
I don't recall anyone telling me to use it. I think that was my manner of trying to characterize what I understood from my review of the records and the nature of the Miller and Lux operations through 1914.
Do you understand that the phrase plan or proposal for progressive development is a legal term of art?
I have since come to understand that, yes.
How have you come to understand that?
I think that was brought to my attention after I had prepared my written testimony.
Who brought that to your attention?
I believe counsel. I couldn't say precisely who.
Was it Mr. O'Brien?
I don't recall.
Okay, thank you. Can we please pull up exhibit Buena Vista 800, please? Thank you, Ms. Mullen. Dr. Meltenberger, are you familiar with this state board order?
I don't believe so. Well, I recognize Lake Arrowhead Community Services District, but I don't believe I've ever read this order.
Did you review this order in preparing your testimony?
No, I did not.
Can we please turn to page 9 of exhibit Buena Vista 800? Dr. Meltenberger, do you see about 7 lines down? There's a sentence that begins order WR 95-10.
Yes, I do.
You see the next sentence, which states this does not imply, however, that a single document expresses the entire intent, but rather that there is substantial evidence of the initial intent with respect to the use of water.
Yes, I see that.
Did you consider this order in preparing your opinion about the lack of a plan for progressive development by Miller and Lux before 1914?
Objection asked and answered.
let's hear the answer one more time.
I did not review this order.
Thank you. Can we please pull up exhibit Buena Vista 801, please? Ms. Mullen? Dr. Miltenberger, do you recognize this first page as to what this document is?
Yes,
Do you cite this document in your testimony?
I do cite portions of this, and I believe this is the, actually, it's kind of hard to see if we can go back out a little bit. Yes. So I do cite portions of this. This is the transcript on appeal from the title insurance litigation.
Okay, thank you very much. And just to clarify what it is, this transcript on appeal contains more than simply transcripts by court reporters, correct?
That's my recollection, yes.
Does it contain typewritten copies of contracts?
I would have to refresh my memory by reference to the table of contents to precisely identify everything that was in it.
Okay. Do you know whether the transcript contains typewritten copies of court pleadings?
That's my recollection.
Was this transcript available at the state archives?
Yes.
Do you commonly use this sort of historical transcript in your historical work?
Well, every project is different. It really depends, but this is a type of source that could be useful for understanding the past.
Thank you. You identified this as the transcript from the title insurance and trust litigation. Is that accurate?
Yes.
Was Miller and Lux a party to that litigation?
Yes.
Was the trial in this lawsuit in 1913?
Yes, I believe so.
And the California Supreme Court's ultimate decision was issued in 1920, correct?
That's my recollection, yes.
Did this litigation overlap the date December 19th, 1914 you use in your testimony as a date for reasonably approximating land and water use within Buena Vista's service area? That was a complex question. Let me withdraw and I'll start again. Did this litigation overlap the date December 19th, 1914?
I don't recall the exact date of the trial, when it began and when it ended. That would be reflected in the pieces of transcript that are here.
You just stated you thought the trial was in 1913, correct?
Right, but I don't recall when it concluded.
Okay. So the trial was in 1913 and the California Supreme Court issued its decision in 1920, correct?
Yes.
Did this litigation overlap the date December 19th, 1914?
Oh, I better understand your question now. Without knowing precisely how all the elements, as I sit here, knowing all the elements of the litigation proceeded, certainly 1920 is when the Supreme Court issued its decision. 1913 is when the trial was held.
So just to ask one more time, this litigation overlapped the date December 19th, 1914, correct?
Yes.
And you used the date December 19th, 1914 to identify what you believe is a reasonable approximation of land and water use within Buena Vista's service area, correct?
I don't quite understand the question.
Okay, let me be a little more specific. Can we please go back to Dr. Miltenberger's testimony, exhibit KWBA1? And can we go to PDF page 31, please? Dr. Miltenberger, in paragraph 43, you see that you use the date December 19th, 1914 as a date for reasonably approximating irrigation within Buena Vista Water Storage District service area?
Well, I see the statement, but I wouldn't quite characterize it the way that you are.
Do you use the date December 19th, 1914 in this testimony?
I do.
And do you state prior to that date, an approximation of land and water use within Buena Vista Water Storage District?
Well, just to be clear for the record, what I'm attempting to present here is that this assessment by Bulletin 9, in my view, provides the most reliable approximation prior to 1914. So maybe I'm agreeing with you. I'm just not understanding what you're getting at.
Move to strike is non-responsive. Dr. Miltenberger, in this testimony, do you use the date December 19th, 1914 as a date for reasonably approximating land and water use?
Mr. Becerra, I'm going to stop you there. I think you're from my reading, I think you're mischaracterizing Dr. Miltenberger's testimony in this statement. I mean, maybe you should look at it again. He does not say, and I'll let him answer, but he does not say that he's using the date December 1914 as the date to most reasonably approximate land and water use. That's not how I understand the statement. So maybe it's appropriate for you to, I don't know, if rephrase the question or come at this another way, because I
think I can probably shorten this.
Great, please do.
Thank you. Dr. Miltenberger, why did you use the date December 19th, 1914 at all in your testimony?
Well, I understand from my prior work that that particular date has importance for the assessment of pre-1914 rights.
Why do you understand that date is important?
I understand it's important because in my prior work over the past 15 years, looking at these issues, and it's exposed me to elements of California water law, and I understand that this date has significance within California water law for assessments of pre-14 water rights.
Thank you. Can we please go back to exhibit Buena Vista 801, please? And let's go to PDF page 119. And if we could scroll down, first of all, actually, can we go back to the top just to identify the page we're on? Dr. Miltenberger, do you see we're on transcript page 573?
Yes.
Thank you. And can we please scroll down until we see the name James Ogden? Thank you. Dr. Miltenberger, do you see that Mr. Ogden testified in the 1913 trial in this matter?
Yes.
Do you know what position Mr. Ogden held at the time?
If memory serves, I believe he was superintendent of Miller and Lux's ranches in Kern County.
Thank you. Dr. Miltenberger, you don't cite Mr. Ogden's 1913 testimony anywhere in your testimony, do you?
No.
And this was in a 1913 trial involving Miller and Lux, correct?
Yes.
Okay. Can we please go to transcript page 588, which is PDF page 134? And Dr. Miltenberger, I recognize you may need to refer to the index, but do you recognize that this is still Mr. Ogden's testimony?
Well, again, I would need to see the index to be sure.
Understood. Can we please go back up to page 1 of this document? And let's see if we can go to, I believe it's PDF page 7. Okay, can we scroll down, please? Thank you very much. Dr. Miltenberger, do you see that Mr. Ogden's testimony included page 588 of the transcript?
Yes.
Thank you. Can we please go to back to PDF page 134, which is transcript page 588. Thank you. Dr. Miltenberger, do you see the parenthetical near the top of the page entitled "Witness here produces map"?
Yes.
And if you could take a minute, could you review the following paragraph? I just want to see if I can summarize it accurately for you.
I think we need to scroll down so I can see the remainder of the paragraph. Thank you. I think does it go more on this page, or is
it may need to continue to the next page. Please feel free to read through the end of the paragraph.
I'm just going to interpose an objection here. I think the map itself being referred to is the best evidence of its contents. And if we're going to ask Dr. Miltenberger about questions about the map, I think he ought to be able to see the map as well.
Well, Ms. Kinsey, I'll represent, we're getting to that briefly.
Great, thank you. And Ms. Mullen, please scroll on to the next page, I think, to finish this paragraph. Thank you.
we continue to scroll, please? Okay. So precisely where am I being asked to finish reading?
Yeah, well, to the queue where the next question is.
Okay, may we actually scroll back up to see the beginning of this? Because it seems like, if memory serves from just the quick look I saw at the index, this is Mr. Ogden under cross-examination, and I'm curious as to what provoked the this testimony. What question he was being asked?
Yes, Ms. Mullen, can we scroll up so Dr. Miltenberger can see the question?
Thank you, Ms. Mullen.
Okay, I think we need to scroll to the next page, please. May we continue to scroll? Thank you. May we continue to scroll? May we continue to scroll? Okay, may we continue to scroll?
Dr. Miltenberger, please let us know when you're ready to talk about that map.
Well, I've read through that last line identified 1767.
Thank you. Okay, could we go back to the preceding page, which is transcript page 588, and go up a little bit more? Oh, so Dr. Miltenberger, do you see immediately under the parenthetical, Mr. Ogden was testifying about maps that Miller and Lux made?
Yes.
Do you see that he testifies that they make new maps of their facilities every year or two?
Yes.
Do you see that he stated he was testifying about a map made in 1912?
Yes.
Have you produced that map as an exhibit in this proceeding?
No.
Have you ever seen that map?
I can't recall that I have.
If we could find that map, would it be your professional opinion it would be useful to understand Miller and Lux's intent for water use before 1914?
Well, I think it would be an additional data point, an additional source of information that I would need to place into context with the information and data that I've discussed thus far, and potentially others. This is a pretty lengthy discussion that Mr. Ogden offers here. I think I'd even need to read perhaps or refresh my memory about the totality of his testimony and the transcript in general before I could say with any kind of certainty about what the import of that map might be.
You cited this transcript in your testimony, correct?
I relied on portions of this testimony cited in my written testimony.
You had this transcript available to you in preparing your testimony, correct?
Yes.
You did not cite Mr. Ogden's testimony in your testimony, correct?
I did not cite Mr. Ogden.
Did Mr. Ogden's 1913 testimony as Miller and Lux's Kern County Ranch Superintendent occur after preparation of the 1885 Hall map you presented?
Yes.
Did Mr. Ogden's 1913 testimony as Miller and Lux's Ranch Superintendent occur after the William Hammond and Hall 1885 sketch you presented in your testimony?
Yes.
did Mr. Ogden's 1913 testimony as Miller and Lux's Kern County Ranch Superintendent occur after the 1898 Grunsky report you discussed in your testimony?
Yes.
Thank you, Ms. Kinsey. I think this is a good place to break for lunch.
Thank you, Mr. Becerra. I think I agree. May I ask, just for planning purposes, Mr. Becerra, how much additional cross-examination you anticipate for Dr. Miltenberger?
I'm sorry, my apologies for interrupting. I anticipate approximately 2.5 to 3 more additional hours.
A lot. I mean, he
Yes.
has a lot of testimony. So, I mean, I may move you along at any point when I think it's not productive, but in general, I think it's appropriate.
I appreciate that, Ms. Kinsey. Buena Vista takes this matter very seriously. As you heard, Kern Water Bank Authority proposes that Buena Vista's water right be quantified at less than half of amounts of water that Buena Vista has used historically.
Understood, Mr. Becerra. So with that, for our planning purposes, I'm intending that we break for lunch. Before we do, is there anything else that we need to discuss or should talk about before we break for lunch for an hour? I would plan that we take a full hour and reconvene at 1:05. Are there any comments before we break? All right, thank you very much. Let's break for lunch and I will see you back here at 1:05. Oh, I'm sorry, a reminder to everyone, we will, because of our AHO, our YouTube streaming, you will need to log out of the Zoom call and log back in. It's the same link, but we do need to do that for our streaming on the YouTube channel. So I appreciate that and I will see you back here at 1:05 p.m.
Thank you.
Council, can I have the spelling of something like Grensky or something?
Yes. GRUNSKY. Hopefully we can do that without reverting to my attempt at the military alphabet.
Is there anything else we can help with spelling? And please feel free, as you have, to ask.
So far, so good. Thank you for helping me.
Thank you. Thank you very much. We are on recess for lunch.